Picking up the comments your Lordship was making before the short adjournment about negative declarations, perhaps convenient just to look briefly at the law in respect of negative declarations, because they are not, and I know your Lordship put to me that if people want to start proceedings, it doesn't matter what the reason is. Of course, that's not the position on negative declarations in this issue. They're not a usual animal. The judge set out at 167 and 168 the principles. This is core 128 from a case called BNP Paribas and Tratamento, that they were not in dispute. And this is a judgment of Mrs. Justice Cockrell, Commercial Court. And she summarizes, so this is paragraph 168 of the judge's judgment, the principles. The case is in the bundle, but it's probably sufficient to take them from here and on this point. I conclude the interesting argument I've heard on the authority has been in danger of over-refining a discretion.
Do you want us to look at that whole paragraph again? I'm sure it's very familiar to my lords, but are you going to just ask us to look at this?
Read that? Would you like to
yes.
read it if you read
yes.
it again, if you're good enough to do that?
Right, so all that spec makes great sense. Where does it take us?
Well, and then this is the context in which he says at 169, in the following paragraph, the claimants submitted with force the question whether it would serve a useful purpose. The claimant said a question for trial. Defendant said it's an issue I can grapple with in an early stage, and I accept the standard I have to apply to this question is the summary judgment standard, accept the potential futility of declaratory relief, and in some circumstances seen at the outset to be fatal to the claim. So that's the background. Again, there's one other authority that he refers to that I think is relevant. I'll take in a moment to, which is Messier Doughty. We can take, I think, the facts quite helpfully from the judge's summary at 170. It may be I've just invited you to read 170.
Thank you very much. Yes, how far do you want us to go on?
If you can just pick up, I think it's probably easier to pick it up. I mean, there's an overlap between the points raised by the judge and the points I want to show the court, but it's possibly easier at this stage to go to tab 4 of the authorities bundle and just pick up the Lord Wolfe in that. And page 75 of that bundle, paragraph 41, Lord Wolfe, in a sense, what he says I think is consistent with the summary that George has just seen from Mrs. Justice Cockrell. And then paragraph 42, on page 76, negative declarations can perform a positive role. There are unusual remedies, as far as they reverse the more usual roles of the parties. Natural defendant became the claimant and vice versa. Can receive in procedural complications possible injustice to an unwilling defendant. This justifies caution in extending the circumstances where they are granted, but subject to the exercise of appropriate circumspection. There should be no reluctance to their being granted when it's useful to do so. So the judgment on this point relates to Sabina, and it wasn't a stay application. It's relevant negative declarations. And if you see the argument in paragraph 45, which is picked up in, so it's perhaps convenient if the court would read the points made at 1 to 5 on paragraph 45 on the next page.
Yes.
Then 46, looking at the situation as a whole, conclusion as a matter of domestic law, joinder is not justified and inconsistent with resolving the English proceedings justly. Savina should therefore, unless this be inconsistent with the policy of the Convention, be dismissed, essentially relying on the practice set out above. And then in 47, which is the passage referred to by the judge, not a situation where the question of the joinder of Savina can be considered in isolation from the question of jurisdiction, and conclude that nothing in the Convention that requires Doughty to bring proceedings in England, and if proceedings are brought, England doesn't have exclusive jurisdiction. And what the judge said about that, I mean, in a sense, this is an example of the negative declaration of jurisdiction, where what the judge says about this at 175, in my submission, is entirely correct. 175 is the judgment. The situation in Messier Doughty has an important similarity and an important difference to the situation in the present case. The similarity is the defendant is an unwilling defendant who has proper reasons for not conceding the declaration sought, but is not the true or primary opponent of the claimant in respect of the subject matter of those declarations. The difference is that the Brussels regulation, and he says that there's an exclusive jurisdiction clause, of course, in the present case, doesn't think that concludes the matter as to whether they should proceed to trial. It's because of the question of, and then he goes on to the question of utility. So the jurisdiction, so what the judge has done is he has taken the view that because they are negative declarations that are being sought, in the circumstances where he sets out, there is no arguable case at the moment. He's relying on Messier Doughty, in a sense, as an analogy, in circumstances where the court was effectively refused to permit the action against Sabina, in circumstances where they were, as he said, unwilling defendant, proper reasons for not conceding, and not the true or primary opponent. That sets up what he comes to deal with in 176 onwards. So in the light of that, we go, that's the negative declaration law. Here we go back to the proceedings in the Vatican. As I think we saw this morning, Article 9, which I think a friend referred you to his submissions, which is a supplemental 281. It gives a civil action may not proceed or continue, so this is Article 9, before the civil judge while the criminal case is in progress, and until an irrevocable judgment on the same is pronounced, unless otherwise provided for by law. So the party can't start a civil action while it's ongoing. And of course, you will have in mind that the indictment as a whole, to which the Secretariat of Party Civil, I showed you the 11 or the 10 charges which relate to Mr. Mincione, but actually, if you look at the document that a friend showed you this morning at supplemental 240, which is, I think he relied on the declaration of Mr. Severino for the purpose of being made a party civil. This is supplemental 240. And actually, in relation to other matters, there hasn't been a translation of the indictment in relation to a variety of charges that don't affect Mr. Mincione. Now you can see on the whereas, which is halfway down 240, that it relates to, and you can see that in the bottom of the page, that after referred to all these various defendants to the criminal proceedings, and there's a mass of them, And then it refers right at the bottom of 240 to the offences and violations mentioned in charges, and they more or less go on forever, 240 to 241, or 241, and you can see that, I mean, there are about 35 charges or something of that nature. So it is a small part of a whole. We only have in translation in the fresh evidence bundle the bits of the indictment which are relevant to Mincioli. The application to be a party civil is in relation to the entire indictment in respect of all these various defendants. The learned friend accepted this morning that nothing that in the Vatican proceedings would give rise to any form of issue estoppel. It's an entirely different set of proceedings. And as I sought to show the court this morning, it is a cause of action under the Vatican statute, which is simply not the same as the civil liability in England. So that is the background of the party civili. We then go back in the light of that to what the judge said.
It's a cause of action which you say is not the same as civil liability in England, but do you accept it is one which is nevertheless subject to the exclusive jurisdiction clause in the contracts, to the extent that it relates to the London transactions?
No, because you couldn't bring the cause of action in England based on the Vatican law statutory cause of action. I mean, if you think about, for example, in Donahue and Armco on anti-suit injunctions, they talk about the fact that there is the RICO cause of action is something that doesn't exist in the other jurisdiction. There is no cause of action in respect of a Vatican law statutory criminal. It's ancillary. The judges obviously made findings on this, but it's ancillary to the criminal proceedings. And he's been quite careful about. He's dealt with it in some detail, and in a sense, I mean, I may say these are findings of fact. I know it's an interlocutory appeal, but in a sense, he's dealt with it in some detail on all the evidence, and he's explained what is meant by it in paragraph 70 onwards. I don't accept that it's covered by the framework agreement at all. It is a separate cause of action, and it's based on. I've sought to show you the material we have about the basis. It's an adjunct to criminal proceedings, and it's based on loss caused by the criminal activity. So that is the basis on which. Sorry, so we then go back to where the judge, having dealt with Messier Doughty and the Mrs. Justice Cockrell's judgment in Paribas, we then go on to 176. Now, so he's set up what he said in what he says in 176 to 179 by showing the jurisdiction on negative declarations, and now he says that the findings I've made in relation to the defendant's central argument become important. Now that was, as I think I mentioned to you before the short adjournment, the findings he made were those findings we saw in the 70s, which were to reject the fact that it would have an effect in the Vatican proceedings, but to accept a purpose in order to put this before the Vatican tribunal. So that is what he's already found, and he's looked at the evidence in order to reach those conclusions. And that's why he says the real adversary of the claimants is not the defendant, but other organs of the Holy See or the Vatican State, and in particular the OPJ. Now, your Lordship's focused on that this morning, and in a sense, provisionally criticised it. But what he's saying, we can see now in my submission what he's getting at. What he's saying, that the various planks are, one, the confusion that I've shown your Lordships in the claimant's case at every stage between the OPJ and the defendants. 2, the purpose which the judge has set out in 77 and 78 and in that section as to effectively to use this for the purpose of the OPJ proceedings. The ineffectiveness of that purpose, because nothing is going to affect, nothing in this is going to affect them. The fact that the defendant hasn't made or indicated a claim other than in the context of being a party civile, which I've shown you what that is, that is the context in which he's saying that the real adversary is not the defendant. In other words, what he's trying to do is use these proceedings to get at the OPJ. And that arises out of the other findings which he's already made. Now, then the next bit, which my learned friend says is inconsistent, but it isn't. What he's saying is that he accepts that the definition of what is a dispute is extremely wide, and therefore it can't be said there isn't a dispute for the purpose of jurisdiction. So that is a completely different question from whether there is an arguable case as to the utility and of negative declarations in these circumstances. And then he makes a point about documents and witnesses. And I think your lordships asked their friend what was the useful purpose. What is the answer? Effectively, he said, well, we've made a non-abusive claim and tracked the contractual terms. That's what he said. And with great respect, that just proves the point. That may be good enough if you're starting an action for damages or something of that nature. But where you're trying to show, in the rather complicated circumstances of the present, that this has a useful purpose, sufficient in respect that the court may grant negative declarations, in our submission, that exactly proves the judge's point. There isn't a purpose in this, other than one which is ineffective and useless. So,
I just wanted to ask you again about this. Let's suppose the claim proceeded and that the English court case managed it properly, narrowed the issues to ones that were actually reasonably germane, decided that it was going to reach a conclusion about whether this was a bona fide transaction or a fraudulent transaction, the sale of the property, and concluded that it was a bona fide transaction.
Yes.
Of course, it might conclude the opposite. Yep. On that hypothesis, how can it be said that that serves no useful purpose? Because you've got to look at the context in which it's being done. But that's exactly what happens unless you doubt it. To the third party, whatever the complicated web that is being alleged in the Vatican proceedings, is to do with a very understandable idea that a property is being sold vastly above its true value, in order that the excess can be creamed off or money can be laundered or whatever it is. Now, and a very substantial property. So why is that of itself not something that represents a useful purpose of a litigation?
But that's true. I mean, if that were right, every action for a negative declaration, you would simply say, serves a useful purpose, and that's contrary to the authorities in my submission.
See, so what remedy is left to somebody in the position of this appellant?
But
simply defend the criminal proceedings.
Well, the criminal
in another state, which is not the contractual state that was involved with the actual property transaction in question.
But the defendants haven't said they're going to bring a claim against Mr. Under the framework.
So what you say, he's just got to hunker down and put up with it.
Well, he's going to have to anyway, because the criminal proceedings will continue, whatever happens.
Yes, but you're saying that the only venue that is open to him is as a criminal defendant in the Vatican.
But no, with respect. But
well, where else? Where else can he go?
What is he seeking to achieve in respect? That's the problem. It's the same as...
Well, I think in a word, as I'd understood his case, the judge said it was a counterblast. He would probably put it rather differently in terms of vindication or something of that sort. At the moment, as you can tell, I'm having difficulty with saying that wherever the merits lie, he may fail. But what's wrong with that?
But if you look at...
In terms of useful purpose.
You look at the circumstances. Either the criminal proceedings succeed, in which case...
Yes, why should he have to wait till the criminal proceedings reach their conclusion?
He's going to have to anyway.
Yes. I mean, I appreciate it may not be convenient to you to defend the proceedings in this jurisdiction, but you may succeed, you may not. But at the moment, seeing as it's not a point of, this is not a term of art, useful purpose, just a plain ordinary concept, I'm completely failing, speaking for myself, to grasp why, however misguided you may show it to be, however fraudulent you may show the behaviour to have been at trial, why that doesn't represent a useful purpose.
But because one looks in the light of those authorities. I mean,
I don't find the authorities to be taking me anywhere near a conclusion. That's why I'm interrupting you.
Yes. The starting point is to look at the circumstances and why he's brought. The passages I showed you before.
Yes.
And actually, what the judge has done is he's looked at the purpose of bringing these proceedings, and he said, and he combines that with what he says at 175, like residuality. This is an unwilling defendant who has proper reasons for not concealing the declarations sought. Is not the true or primary opponent. It's got to be seen in the light of the circumstances in which he brought this.
Yes, but if the judge was wrong about the primary opponent point, and he was wrong on ground 4.
But that begs the question with respect.
I see you seek to bring this into the consideration of ground 4, but if the ultimate conclusion was that your client was not a neutral minister in the Vatican proceedings, but was in effect suing, everything else falls away, doesn't it?
Well, it's not as the question is not neutrality but utility. That's the neutrality, of course. I mean, it's the expression used by the judge, and I understand that, but it's actually all about utility, and that's what the judge is finding at 176 to 179.
Well, there are two different ways of putting the same thing.
Well, no, they're not. They're not with respect. I appreciate that your lordship's. I mean, it may be part of it, but the utility is a much wider concept. It's actually, will these declarations serve a useful purpose in the light of...
Well, could the judges, accepting that they may not have a complete overlap, could the judge's conclusion on utility survive if his conclusion in relation to neutrality was not open to him?
Yes, it could. Yes. I mean, I appreciate it's part of it, of course, but his utility goes significantly further than neutrality. You've got to look at the circumstances taken as a whole and say, what is the purpose of these proceedings?
For whom? Purpose for whom?
Well, it's objectively, in the same way as you've got to look at the purpose in the case law on negative declarations, as to you've got to look at will it serve a useful purpose?
Well, I can imagine you look at it from the point of view of the claimant. You
Yes.
look at it from the point of view of the defendant. You look at it from the point of view of the administration of justice.
Agreed.
And general overall
Yes.
considerations of that kind.
Exactly. So, what is the purpose from the claimant's point of view in that? And then the judge has gone through the circumstances in which the action was commenced and brought, and looked at that in detail, and he's made findings in respect to that.
But isn't it a rational thing for somebody in Mr. Vincioni's position to say, well, I may not be able to get what I'd hoped to get out of this action because a decision of the English court is not going to cut any ice in the Vatican, but nevertheless, I can still get something which I regard as useful, namely vindication of my position from the court which the parties agreed would determine any dispute.
Well, this is the tip of the iceberg the Vatican proceedings, as I sought to show, Your Lordship. I mean, the Vatican proceedings are all about conspiracies between 2012 and 2019 involving vast amounts of money.
Well, the judge might have said this is just the tip of the iceberg, and that's a reason for staying the action on case management grounds. But that's not the way he puts it.
But Your Lordships have seen the indictment, and you can see that. I mean, that's why I sought to show you the indictment, because you can see that this is a small part of the whole. So, I mean, how is it that on this part, these negative declarations, which are, as Lord Wolfe was saying, reverse the normal order of things and therefore have to be looked at with caution, how are these going to help anybody? And that's
well,
why
Lord Wolfe did say in the paragraph you asked us to read, paragraph 45, subparagraph 5, that it would be completely different if Sabina had made a claim, which brings us back to the neutrality point.
Yes, but you've got to look at what sort of claim and really the nature of it. And remember, you have my submissions on it. I mean, it's
on it being a statutory cause of action.
Well, it's a statutory cause of action in respect of vast numbers of defendants and vast numbers of charges. It doesn't break down as to which one. And the judge has made findings in respect of the effect of that, having read the evidence on it. And he's actually made what effectively are findings of fact in respect of, as I said, I appreciate it's an interlocutory matter, but he's gone through and analysed the effect of being party civil under the Vatican law on the material available to him and reached conclusions in respect to that. I also showed you the confusion on the part of the claimant between the OPJ and the Secretariat in their points of claim and their submissions in respect of that, and what they say about that and their evidence, where they are actually proceeding on the assumption for a large part of those that what the OPJ does can be attributed to one way or the other the Secretariat, which has been debunked, as it were, so that it proceeds on, as it were, a false basis, but ineffective in purpose. The fact that the defendant has not indicated a claim other than, we talked about party civil, that is what gives rise to 178. And the other party before the court is not before the court. It's that actually this isn't going to determine anything useful because it's all going to happen in Italy in any event, in the criminal proceedings. So that is why the judge reaches the conclusion at 178 that this is a paradigm example of a claim barred by the principle of utility. And I mean, that's the basis on which he does that.
How is a negative declaration to be defined? What makes a declaration a negative declaration?
It's a declaration that your lordship is not liable under the contract dated. It's a declaration of non-liability normally. It's often done in jurisdiction disputes, where one party, often where there's, for example, a jurisdictional battle, one party tries to get in first before the other party sues on a contract. One party comes to a different court and says, I want declarations that I'm not liable, or something of that nature.
All right. I was just wanting to remind myself of what the terms of the relief that was sought in the particulars of.
The 220. If you look at
paragraph 34 of the
that's right.
Of the particulars.
That's a vast number of declarations being sought. And the claim is at 250, declaratory relief as pleaded in paragraph 34.
So starting on page 243, we have the long list.
Some are positive, to be fair.
Right, can we get to the... I can see that...
37.
without being tedious about it, I can see that There are some was nots, but there were plenty. There are plenty of.
Look at 37 on page 249. I think that's the principle.
Yes, well, I'm trying to unpick these various points, but take, for example, 34.3.1. And I can quite see that for any sensible sort of trial, there might have to be a very considerable amount of case management. But as there isn't haven't yet reached the point of having a defence, it's impossible for the court to fully know what the real issues might be.
Well,
but I mean, if you would just take 34.3.1, is that a negative declaration?
No, no, it's not. It's a positive declaration.
Yes,
how the court would grant a declaration in those terms seems pretty unlikely. But,
sorry?
How the court would grant a declaration in those broad terms seems pretty unlikely, but that's a different point in a sense.
Well, I mean, to take a different situation, I mean, let's suppose that, not to do with this case, but that somebody had published an article in the newspaper saying that my house purchase was a fraud, and I wanted to vindicate myself, and I sue them. It would lead to a trial as to whether, essentially, for the truth of that issue. I'm not sure why we're in negative territory.
Your lordship's quite right. I mean, I think some of them are negative, and 37 in particular is a negative.
Yeah, I mean, maybe what you'd be entitled to say, although the judge didn't, it seems to me, base his decision upon this, but some of the relief sought in this action is exorbitant. But when one goes back to the core of it, it might be said, even, and again, this is a point you've made, but I don't find it in the judgment, that this is a tip of the iceberg, that if one takes the property valued on anybody's account at hundreds of millions of pounds, what's wrong with a declaration saying that that property transaction was within the realm of the normal?
Well, if it's not wrong in principle, in the sense the court's got jurisdiction to make them, but still the court won't make declarations unless they're useful.
I understand you won't make it if they're academic or futile, or if it's being done better elsewhere and so forth. But
they're very broad.
But it seems to me that your negative declaration point, we could work through this, but we won't, might apply to some, but not to others. And certainly, insofar as it relates to exemption from any liability anywhere ever, the court is highly unlikely to entertain that to trial.
I think I accept your lordship's point that, well, not in negative. The gist of the declarations are to the effect that we did nothing wrong and have no liability under the contract, under the framework and agreement and the SPA. That's I think the gist of what they are, which is although it's not technically negative, but in light of 37, it is essentially, it's in substance, declarations that we did.
All right.
I mean, the practical reality, as it seems to me, is that if the stay were lifted, the Holy See, or the Secretariat, rather, would have to decide whether to put in a defence. If it puts in a defence, then that defence will set out the respects in which it makes complaints about the transaction, and the issues will become focused, which is what pleadings are designed to do. And in the light of that, the court would be able to have a trial which focused on those issues and decide in the light of whatever it decides on the merits what declarations to make. Now, I suppose if the Secretariat were to decide not to defend the action, then the court would have some case management to do as to decide how it was going to proceed and what evidence it wanted to hear and what declarations it might make. But one would expect that a defendant in this position probably would want to defend, in which case some of the problems which certainly do arise on these very broad formulations would be likely to fall away in the course of the proceedings once it became clearer what really was in issue.
Well, yes, I think that the premise of your lordship's point is that that would be the consequence if this court took the view that the judge was wrong in those paragraphs of the judgment where he says that these serve no useful purpose for the reasons he's given. I think that would be if...
Yes, well, either if we were to allow the appeal or if the judge had not imposed a case management stay in the first place. Should the action simply proceed?
Yes, if he allowed the action to proceed, then those issues would arise. So, but I mean, your lordship's right. I mean, that's how. I mean, exactly how an action would go is interesting question. I mean, your lordship's posited various possibilities. It might be said that it's impossible to try the bits within the jurisdiction clause without getting into quite a lot of background as well. But that's not perhaps the point for today.
Yes. Well, I mean, the kind of considerations which would arise are for further down the road.
But that's if
there is
that's
a clear
all.
road.
That's only if the court takes the view that the judge was wrong in his primary conclusion at 176 to 179. That's the effect of it.
Yes, or if the appeal is dismissed, but there is some material change of circumstances and the action revives.
Absolutely.
You've still got all the problems about how you're going to deal with these very broad declarations.
I mean, the judge, as you can see, he's recognised the possibility that there is a change of circumstances and that an application is made on that basis to lift the stay, in which case it would proceed even if your lordship dismissed the appeal, which is, as you know, our primary position, which is on the basis of what the judge said in those paragraphs, that he was justified to do that for the reasons that I've sought to identify. The effect of that is, it's not as though he is barring the claimants from going to court. On the contrary, he's simply saying, I don't see this work for the reasons he's given, and I've addressed you in some length. This isn't going to work as things stand, but things may change. So that's the. So that is. I mean, in a sense, I think it comes down almost certainly to those paragraphs of the judgment and whether this court is satisfied that, notwithstanding the findings of fact of the judgment, and which I've sought to take you to the basis of, and the circumstances in which he did it, and notwithstanding the fact that those are findings of the judge and your lordship's being asked to interfere with them, as to whether there is, those I think are the key paragraphs and the key part of it. I need to deal also with the case management stay, which I haven't really touched at all. Can I just pick up one particular point, which is the point raised by the claimants, that the judge ignores the position of the first to third claimants and focuses on Mr. Mincioni, which I would, so that what then a friend sought to argue was that one can't say there's no utility against the first three claimants. That's the point they made. The judge picks that up at 79 of the judgment, which is at page 105 of the core bundle. And he says at paragraph 79, he makes the point, whatever might be said about Mr. Mincioni, the other claimants are not accused of any wrongdoing by the OPJ. This is the argument. And it cannot be said of them, 79, that their real dispute is with the OPJ rather than the defendant. I accept that as far as it goes. There's no evidence to suggest the corporate claimants have been operated other than properly in accordance with their constitutions and the law of Luxembourg. The evidence on behalf of all four claimants has been given by solicitors and by Mincioni. I found nothing to indicate that any of the claimants is acting for any reason other than those Mincioni has given. I don't consider any different position to that of Mincioni as far as concerns the purpose or usefulness of the present proceedings. So the judge actually made a finding about that. There is quite a lot of evidence as to where Mincioni treats himself as being the same as all the claimants. And I would suggest the suggestion that he's that they can be treated separately is entirely unreal. If I can just show you paragraph, page 231 of the supplementary bundle. This is in Monsignor Carlos's second statement at paragraph 36. And what he does in paragraphs 36 to 41, we perhaps needn't go into detail. What he seeks to do is to show the circumstance, the relationship between Mincioni and the first three claimants. We say, the defendant suggested that in their evidence that he appeared to control them. He disputes that. But there's obviously a close relationship and he signs on their behalf and so forth. But what Monsignor Carlos says at paragraphs 36 to 41, and we needn't go through it in detail, is he tracks all the comments that publicly Mr. Mincioni has made where he purports to treat himself as being the first to third claimants. In particular at 39, he's talking about what he did and what he invested, whereas in fact the position is that of the first to third claimants. So those paragraphs and the 36 to 41 set them out in detail as to why Mincioni treats himself effectively, or has treated himself in a lot of the things he said, as being the same as the first to third claimants. His fingerprints are effectively everywhere on this, and the idea of drawing a distinction in some way, and suggesting that there's some utility so far as the first to third claimants, or not, and not in respect to, even if there isn't a Mr. Mincioni, is, in my submission, entirely unreal. So that's that particular point. I was going to deal with the case management stay. Now, can I just explain the law in respect to this? Article 25 requires the court to accept jurisdiction, but notwithstanding Article 25, Section 49.3 of the Senior Courts Act and CPR 3.1.2.f provide the power to grant a case management stay, and in doing so the court must obviously consider the overriding objective. My learned friend sought in some way to limit this power, but that's completely wrong in my submission. So one thinks about this example. For example, the 2015 Act, which authorised collective proceedings, all the claims which had been brought under that were effectively stayed pending the decision of the Supreme Court in Merrick's and Mastercard. That's a case management stay where the basis of a jurisdiction is about to be determined by an appellate court, and therefore it makes sense to hold on to and not to proceed with cases until the court has determined the extent of that. That's got nothing to do with foreign proceedings, but that is an obvious example of a case management stay. There are plenty of other circumstances. It's often used in domestic proceedings. It's another circumstance, which I'll come on to in a moment, is where it may well be unnecessary to have proceedings pending another action, and they should be delayed until thereafter. The key, I would suggest, in terms of this jurisdiction is actually a rather simple one. Many or most of the cases where people have sought case management stays are effectively forum non-conveniens applications in disguise. And if you look at the authorities, Maratelier is one of them, Mazur is another, Ness is a third one, we needn't go through them. They're all cases where, under the guise of making a case management stay, party actually tried to remove the case from one jurisdiction to another. Now, the difference, I would suggest, is actually the following. A jurisdiction application challenges the jurisdiction. A stay application for a case management embraces the jurisdiction and recognizes that the court has jurisdiction over what it is, and therefore doesn't seek to challenge that jurisdiction. And I think that is the basic distinction. And in my submission, if you're with me on utility, that falls exactly within the circumstances where it's appropriate to have a case management stay. because there's nothing about that that is seeking to challenge the jurisdiction. On the contrary, it's recognising it. And Reichhold is a helpful case in respect of that. Can I just show you that? It's tab 5 of the authorities. Now, it's quite interesting because it's quite a powerful case, and it's normally, learned friend accepted this as the jurisdiction below, although I think he sought to resolve from that before your lordships. Reichhold sets out the jurisdiction. Reichhold had sued, so tab 5, page 80 of the authorities. Reichhold had sued Goldman Sachs and Jotten. Jotten, there was an arbitration between Reichhold and Jotten under a sale agreement. And Goldman Sachs, there was a claim brought in England under engagement letter. Goldman Sachs sought a stay, a case management stay. And if you look at if you pick it up, let me first of all just show you 17. So if you look at 176D, please. And Lord Bingham, and you can see that he says at 176D that the stay was under 49.3 of the 81 Act, pending the final determination of the arbitration proceedings commenced by the plaintiffs, Reichhold, against Jotten. So what had happened, so if you look then, I just want to pick up, so if you look at 178, B to E, perhaps the court would just read the paragraph starting in his judgment. Yes. And then we go to 180H, where the judge returns to his summary of Mr. Pollock's submission to the effect that Mr. Pollock argued, in the circumstance that arisen, was every practical reason for Reichhold to pursue a claim against Jotten under the sale agreement, and no sensible reason for his proceeding against Goldman Sachs in this country. There was a lot of force in that agreement, in that argument. In truth, the complaint was well founded and appeared to have a good claim under the warranties, i.e. in the arbitration. The claim against Goldman Sachs was more complicated for the reason that he already indicated. He considered, Mr. Pollock was right in saying, like it is substantial, and then there's the difficulties of pursuing the claim against Goldman Sachs. And then at B, the citation from the judge, not easy to see why Reichhold should wish to pursue these proceedings in preference to the arbitration. No explanation has been offered. Well, there are obviously parallels here. Mr. McCaughrean simply fell back on the proposition that Reichhold is entitled to take that course if it so wishes, and the court shouldn't interfere.
What are the parallels here?
Well, the difficulties in understanding the purpose of the English proceedings. You have my submissions in respect of that. If you look at 180.
No, but it's in preference to the arbitration. So what choice has?
They're suing
has the claimant got? I mean, in this case, Reichhold had a choice of where to.
But what the court is doing here is quite dramatic. The claimant is perfectly entitled to sue both Goldman Sachs.
I understand, but as I think the judge appreciated, this was a case in which there was a Norwegian route and there was an English route, and the judge couldn't understand why the Norwegian route wasn't the better one.
With respect, I mean, it's quite dramatic in a way. So here is a claimant who is entitled to sue two people in two different sets of proceedings in different jurisdictions. One is in arbitration and one is in England. There's nothing to stop.
Where else is the claimant in this case going to sue?
No, but if your lordship, just bear with me. Sorry.
No, well, you said in a throwaway fashion that you can see the parallels. I'm saying yes, but you can also, as the judge did, see the differences.
Well, let me just pick up on the parallels. If you think about this case, this is a case where the claimant had sued two different defendants in different sets of proceedings, wanted to pursue them both, was entitled in the normal way to pursue them both. And it was the defendant in the English proceedings who wanted a stay. And the defendant said, look, the proceedings you are bringing in England are complicated. You are likely to get what you want in the arbitration. So therefore you should not be allowed to pursue pending the stay. So the court was actually at the defendant's behest against the wishes of the claimant, seeking to interfere with the claimant's right to bring those proceedings without difficulty in England. And that is, now, I mean, it obviously depends on the view you take about the findings of the judge. But you know, when we see that,
no, it's not. This my point is not dependent on the judge's findings, because there isn't another jurisdiction.
But there are different claims here. There are different claims in RICO. They're totally different claims. It may be that the result of one is a claim under a sale agreement, and the other is a claim under a confidentiality letter. They're completely different claims. And the court is saying of its own volition, one looks a lot simpler than the other, and therefore you won't be allowed to proceed with the one in England until you finish the other. And that's the court interfering very much in circumstances where they see, the judge took the view, and this court upheld that they were entitled to do that, and that they wouldn't interfere with the judge. That was 181. And then at 183F.
Well, I think my Lord's question, to which I would also like to know the answer, is if the English court says to Mr. Mincioni and his companies, you can't sue here, go and get the remedy you're seeking here somewhere else, where does Mr. Mincioni go?
But with respect, that's the wrong question.
Well,
because
if you choose to say it's the wrong question and don't answer it, that's up to you.
I'm sorry. It's not that he is not going to achieve anything by these proceedings in the circumstances. He's not being prevented. He is being told that as things stand, there is no utility in his declarations because of all the circumstances that I've shown you and that the judge relied on. And therefore the stay was granted by the judge pending a change of circumstances, which would produce at least an arguable case that the declarations would serve a useful purpose. 183F, and then Mr. Carr refers to the wide jurisdiction to grant a stay, and talks about at H there being no reported case before the present in which a judge has made an order precisely analogous with the order the judge has made here. And court says that doesn't matter. Just picking up, I'm not going to show you, I'm not going to read it, but then referred to Abraham and Thompson, which is actually referred to in this 184B. And then if you look at 185F, the 185F, perhaps you could just read that until 186B. That simply it is quite a striking case of my submission, because the court is actually telling the party that it needs to proceed with other proceedings, contrary to its wishes, proceed with other proceedings before it proceeds with these. Just briefly, the only other one I wanted to show you is another referred to Unwired Planet, which is tab 22. On page There's only one paragraph of this. It's the Supreme Court decision. So it's an appeal from Mr. Justice Birss, I think.
Part of it is.
Part of it was.
The on-wide plan bit.
Your Lordship's name is referred to where it says the only relevant page, page 580, paragraph 99. And the only reason, just this is the passage that a friend referred to, but all this is doing in my submission is the Supreme Court essentially saying that the case management stay, English courts have wide case management powers. They include the power to impose a temporary case stay on proceedings. We know that. Temporary stay is imposed or ordered by consent to give the parties breathing space to attempt to settle. That's an ADR stay, for example. It's a type of stay. Or narrow the issues by mediation or some form of ADR. Temporary stay may be ordered parallel proceedings in another jurisdiction, raising similar or related issues in the same or related parties, where the earlier resolution of those issues in the foreign proceedings would better serve the interests of justice than by allowing the English proceedings to continue without a temporary stay, which refers to Reichhold. Well, in my submission, that's simply setting out the fact that it's a wide jurisdiction and giving some examples, but doesn't actually say anything to affect the jurisdiction. So, if I can deal
Are you in line abreast with Mr. Samek that the judge was right to apply the Reichhold approach?
Yes.
Yes.
Absolutely. It was common ground below.
Yes, exactly. I thought so.
Yeah, I think he sought to make some submissions to the effect the judge was wrong and rather slightly inconsistent with what he said below, but Reichhold was common ground. It sets out the position in my submission clearly. So I just deal. I mean, I've dealt most of the points in terms of the grounds of appeal I've actually dealt with in the course of my submission, but perhaps I can just deal with them. The grounds 1, 2, and 3 are all about the stay, which in my submission, the learned friend's submission, is just plainly wrong in law. As I've said, he accepted below, as the judge confirms at paragraph 192 of the judgment, the complete discretion, and that what, in terms of a stay, and I would venture to suggest that the real issue before your lordship and the way the matter has proceeded is the view your lordships take on 176 to 179, and that if you are with me to that extent, then what follows is entirely unobjectionable. If your lordship take the view against me in respect of that, then this one doesn't in a sense get into this. So that's one. And he says it isn't rare and compelling. I think the purpose of rare and compelling is all things being equal. One has a right to have one's case tried in accordance with the overriding objective expeditiously and fairly in this jurisdiction. And therefore, there has to be a particular circumstance where, in order to grant a stay which takes it out of that normal rule, and particularly so where you have an exclusive jurisdiction clause, because in those circumstances, there is the possibility that what one is doing is, as I put it a moment ago, effectively a forum non-conveniens application in disguise. But I mean, the basis of my submission, I think your lordships have it, which is that, as I put it, is the application effectively a jurisdiction application in disguise, or is it embracing the jurisdiction? And my submission, I mean, you don't have to accept that precise formulation. That's what it comes to, in essence. And you only have to look at these cases to see how many of them are actually attempts, forum convenience attempts. Otherwise, I think those really are the points on 1 to 3. Ground 4 is neutrality, which I think I've addressed your lordships on in quite some detail. 5 is, if I may say so, a bit of a kitchen sink. It's a number of matters that I'm not sure. I mean, if your lordships want me to go through them individually, you've gone through them in the skeleton. Then a friend didn't address them orally. We've responded to each in the skeleton. If there's anything particular in respect of there. Incidentally, there is a criticism in Learner Friend's skeleton, although not really made orally. It was touched on about the draft judgment, and it suggested.
I don't think we're going to go there.
I thought not. And the only other point is the duration of the stay under ground 6, And it's suggested that in some way there's an ECHR point here under Article 6. It doesn't restrict access to the court. Every case management stay restricts access to the court, but no one's ever suggested that the power under 49.3 is a breach of Article 6, other than in the particular way it's exercised. And as my Lord Justice Birss put this morning, I mean, all the judge is really doing is saying, if there's you can apply under a change of circumstances, again, all premised on the conclusion he reaches at 176 to 179. He says, well, I don't think there's any utility at the moment, but there might be in future.
So the fact that the precise stay might have been drafted differently, or so it doesn't really matter. If the fundamental conclusion that there needs to be a stay is achieved, then it's clearly not going to avail the appellant that it might have been drafted differently.
Ironically, that was intended again to help the claimants, because we had asked for a wider stay. We'd asked for a stay pending
the end of
the Vatican proceedings, and that was rejected. And the judge granted a narrower stay, and he thought, I think, he was doing that in favour of the claimants. And I mean, how you can, again, subject to the premise, how you can object to a change of circumstances. Say, I mean, my submission, you can't. May I just turn around and see if I missed anything?
Thank you, Mr. Holler. That's helpful. Thank you. Yes, any reply, Mr. Senator?
Lords, briefly, I'll pick up a few points as crisply as I can. Learned friend made a number of points. First of all, he said that there was a confusion in the proceedings in relation to the Secretariat and the OPJ. There was no confusion by Mr. Minchone. Can I just show you in the supplemental bundle, please, paragraph 100.
Well, where is, I don't mean to deprive us of useful references, but where does this go? The judge wasn't confused by it.
He wasn't, no. It's the point your Lordship made.
Whatever confusion anybody may have tried to sow didn't bear fruit.
I can move on. Do you want me to give you the references?
Yes, please.
Simply supplemental bundle, page 173, paragraph 6, and then supplemental bundle, pages 188 to 189, and it's the point about the bullet point in Mr. Minchone's witness statement in paragraph 84, which makes it clear there's no confusion. Then, Lord, again, short point, learned friend kept on saying that there was a conspiracy charge. There is no charge of conspiracy in the Vatican proceedings. That probably won't interest you, Lordships, but since it's been mentioned, I ought to make that clear. And if you want to look at the indictment at the fresh evidence bundle at tab 1, you can see from looking at pages 3 to 9 what the charges are, but there is no charge of conspiracy. And in fact, there are separate trials, and Mr. Minchone is only concerned with one trial to do with the property, but that's by the by. My Lord, my learned friend then made a point about the nature of the civil claim in the Vatican. Entirely irrelevant. The bottom line is, as was put to my learned friend by Lord Justice Males, or maybe I should rephrase that, I shouldn't be supposing what your Lordship had in mind, but that's why I will rephrase the submission. Any civil claim, any claim or any disputation in relation to the transaction falls within the terms of the jurisdiction agreements, which are referred to in the judgment in paragraphs 15 and 20. The fact that a defendant may, in a foreign jurisdiction, in breach of a jurisdiction clause, mount an action following provisions in a codified statute is neither here nor there. The form is irrelevant. It's the fact, it's the substance, which is a civil claim. And that would be in breach of the jurisdiction clauses. So to say, oh, well, the claim is like a RICO claim in the US is not right at all, because I showed your Lordships the provisions. And Article 7 and then 53 and 54 provide for the mechanism by which a civil action may be brought when there are criminal proceedings. And equally, I showed your Lordships that a person who considers themselves to be a victim of an offender doesn't even need to bring a civil claim. He can wait. She can wait until the conclusion of the proceedings and then rely on a res judicata. And I showed your Lordship that.
Then, just from memory, it's the thing they can't do is not to join the criminal proceedings, but to sue away
exactly
before they're finished.
Precisely so, and that's Articles 8 and 9, exactly. And then,
Sorry, Mr. Sam, can I just make sure that there isn't a finding either way about this by the judge, is there? There isn't a finding either way about on the question of whether the civil claim, if that's what it's called, in the Vatican, is or is not a breach of the jurisdiction clause.
no, he doesn't make a finding of that at all. No, that's simply my submission. Correct. Yes, sir. And then, my lord, my learned friend sought to, frankly, if I may respectfully submit, change the case on utility. So he moved to say that what the judge had really found in relation to utility was not based on the fact that the Secretariat was a neutral and that the OPJ was the real defendant but couldn't be brought before the court, but rather he sought to make a point that there was no utility because anything that the English court might declare wouldn't be of any use in the Vatican criminal proceedings. Well, that's not how the point in relation to this was put below. Secondly, it's not what the judge found. And your lordships only have to look at the passages which we set out in the single-page document which I handed up to your lordships, which makes that crystal clear. And in fact, my friend relies on paragraph 178, 179. 178 couldn't be clearer. The first part, fourth line, it's not the defendant who's primarily interested in them at this stage because there is another party who's interested but won't be before the court. And then 3 lines on, to grant declarations which are primarily aimed at the position of a third party who can't be brought before the court, can't reasonably be expected to come before the court voluntarily, is, in my judgment, a paradigm example of a claim which is barred by the principle of utility. So the fact is, utility is the other side of the coin, if you will, from neutrality and the OPJ being the real defendant. And indeed, let me just show your lordships the way it was put below by my learned friend Mr. McParland. If your lordships look at the transcripts bundle, please, tab 1, and it's internal page 61, please, which is page 18 of the bundle itself. At line 6 on page 61, the deputy judge said, just going back to your point at 104, the useful purpose, is it your case that the declarations are futile because the Secretariat of State isn't really the party that's making these allegations? It's the OPJ who's not subject to any of the jurisdiction clauses. Mr. McParland, that's correct. Is that the point you'll make at 104, 105? Yes, okay, thank you. That's the way it was put below. And in any event, one can test the logic of the submission made by my friend, because the logical outcome of my learned friend's submission is that there's never going to be any utility in the English proceedings, because the Vatican Criminal Court, if the English court makes any declaration, it isn't going to pay them any notice to them whatsoever. Well, in that case, why did the judge posit in the judgment that there might be future events which might make it the case that these proceedings had a chance of success? Because if my friend is right, then the judge's point about, oh, well, the Secretariat might lead evidence, they might become, in substance, the real absolute, are non-points. And that illustrates par excellence that what was going through the judge's mind, which is precisely what we have submitted, and precisely not what my learned friend has submitted. My Lord, subjective purpose has got no relevance to the issue of the stay at all. It was considered by the judge in the context of the abuse of process argument. But as my Lord Justice Peter Jackson said, litigants pursue perfectly valid claims, or they may turn out not to be valid, for a variety of motives. Motivation is entirely irrelevant in the normal way. Lords, yes, so my friend then took your lordships to Messier Doughty, and that's a case of some interest, because the decision which the respondent paid a great deal of attention on below was, of course, the decision on the application of Sabina to be removed from the English proceedings, and in which they succeeded. And your lordships will have seen from the judgment at 171 that the deputy judge referred to a decision of Mr. Justice Langley. And can I just show your lordships that's in the authorities bundle, because it is quite instructive. If your lordships can take up, please, tab 3 of the authorities bundle, page 58. That's a decision of Mr. Justice Langley, and that was the application for a case management stay by Airbus. And of course, the problem that Airbus faced was that it was the counterparty to Messier Doughty in an English law contract with an English exclusive jurisdiction clause. And if your lordships can go to page 62, bottom right-hand corner of the bundle, under the heading at D, power to stay, Mr. Justice Langley referred to section 49.3, CPR 3.12F, and just pausing there, my friend said that this power is untrammeled. With respect, it isn't, because when you're dealing with a regulation case, and it's a point which comes out in the authorities, and it's a point made by Mr. Justice Lawrence Collins in Mazur, one's got to have regard to section 49 of the Civil Jurisdiction and Judgments Act, which provides that, effectively, you can't circumvent the regulation. And that's in the authorities bundle also. But you see under power of stay, mention of Reichhold, and then the submissions are recorded at page 63. And then conclusion, the balance of these submissions falls heavily in favour of Mr. Howard and Doughty, so rejecting the case management stay. Far from being compelling circumstances to justify the grant of the stay, in my judgment, there's a compelling case against one. This court is being asked to delay proceedings in the chosen jurisdiction of the parties for a period of over 7 months on the basis of a possibility that something of use in the proceedings may emerge from the expertise. Just pausing there. And one of the themes of my friend's submissions today, which was a submission made below and pointedly not taken up by the judge or referred to in the judgment, let alone as a reason for anything he decided, was that, oh, well, you know, if Mr. Minchone's acquitted, that may mean that the proceedings here aren't pursued, or equally, if he's convicted, then that may mean that the English court's not going to grant him these declarations. Those conclusions do not follow at all from the premises, but it's an echo of what Mr. Justice Langley says here, because he goes on, I use the word possibility, undoubtedly at least a real uncertainty as to what the expertise, that's the expert report into the cause of the failure of the landing gear. He says, I can't see how that can justify a party not pleading its case and making appropriate disclosure. It's the same point here. What is there to stop the Secretariat from pleading its case? Lord Justice Mayles referred to once the defence is pleaded, then the court and the parties will have a better idea, that's been the function of pleading, what the issues are. We've seen how one of the arguments raised by the Secretariat, it isn't the proper defendant. Well, if that's right, that should be pleaded in a defence. And again, these were not points, can't plead the case, can't give disclosure, which were relied on by the judge. And it's a point we made in ground 5, that you should have focused on those points also. And then a point that Airbus knows the case, and then in justice to Doughty at D. And his lordship says this, insofar as the expertise produces little of relevance, there can be nothing to be said for a stay. But the greater the relevance of any report, the more it can be said to trespass on matters which the parties have agreed must be determined in this jurisdiction. And my friend was very close. In fact, he made a submission to say, oh, well, you know, everything can be determined in the Vatican, all of that. But that is going to be in relation to issues which properly fall within the SPA and Framework Agreement Jurisdiction Clauses, precisely trespassing on the jurisdiction of this court. So that's Messier Doughty, but that's dealing with my friend's morning submissions. As far as after lunch is concerned, my friend made a point that the party Trevilla proceeding applies also to other defendants. Short response to that is so what, because it's a claim made against Mr. Minchone. Then, my lords, my friend said a lot of the time, and kept focusing his submissions on Mr. Mincione, just as the respondent did below. One mustn't forget the corporate claimants. The judge made no finding, quite rightly, that they were conducted other than in accordance with the proper legislation in Luxembourg and in accordance with their corporate governance documents. There was no finding that the corporate veil should be pierced, or that Mr. Mincione was some puppeteer, controlling these corporations, which are active trading and finance bodies of some standing. So one can't simply dismiss them at all. And it's a point my Lord Justice Peter Jackson put to my friend, which is, well, if the English court isn't the venue for the determination of the claims, where can they be determined? And there was no answer, in truth, with respect to that question from my learned friend. And that lack of answer applies with all the greater force in relation to the corporate claimants, who aren't even parties in the Vatican criminal proceedings, let alone defendants to any party civile claim. Then, my lords, there was a discussion in relation to negative declarations, and my Lord, Lord Justice Peter Jackson said, well, how can it be said that if declaration, if this court reaches a conclusion that the transaction is bona fide and so on, how can it be said that that doesn't serve a useful purpose? Well, precisely so, with respect. In circumstances where there is a dispute, my clients are entitled to come to this court and have this court make declarations, or let me rephrase that. They are entitled to come to this court to have this court decide.
Well, I think as it were, you're making a short point at length. But
not the first time.
I think by the time we've got to replying, we know what the issue is for us to decide, and we've got your submissions about that.
Very well. And then check my notes. Yes, in relation to, I made a point that my friend said in a lot of the cases that the case management stay was dismissed because the courts perceived it to be nothing other than a forum convenience argument in disguise. But it's not just forum convenience. It's also the fact that the court took the view in some of the cases, such as Mad, Atelier, decision of Mr. Justice Trower in the authorities Borlikova, that the lis pendens provisions of the regulation had no application, and that therefore a case management stay would be a circumvention. So it isn't just forum convenience. And there's also the point made, as I said, by Mr. Justice Sloane in Standard Chartered, that the court also should be astute to see that key issues which should be determined, is the point I made the first time round, should not be determined anywhere else. I'm just going to just check. Lord, unless we can assist your lordships further, those are our submissions and reply.
No, thank you very much indeed. Very well. Well, we thank the parties and those representing them for the way in which the appeal has been prepared and presented. We will inevitably think about this for some time and let you have our decision and judgments in due course, in the normal way, handed down for solely editorial assistance, please, and a draft order reflecting our decision with any matters that you're unable to agree reflected in some short submissions. The judgments will then be handed down electronically, as is now the normal way. Thank you all very much.